following the keynote presentation. As questions come to you, please post them in the chat function box below, and we'll get to them whenever we can. Finally, before I introduce our keynote speakers, I'd like to thank our wonderful sponsors who make our events possible. Our legacy partner, Invert 720 Productions, our seasoned partner, NATE Continuing Education, and our chapter partners, FMAV and Special Event Rentals. We cannot continue our award-winning programming without their ongoing support. So thank you, thank you, thank you. So now I'd like to welcome our speakers. First, we have Emma Johnston, partner with Miller Thomson LLP. Emma is a litigator who advises Canadians and international clients on construction insurance, agricultural, and general commercial litigation. In Emma's construction practice, she often advises residential, commercial, and industrial construction clients on builders' liens matters. Emma counsels her clients in litigation and enforces strategies across a broad range of matters. She has participated in various forms of mediation and judicial dispute resolution. Also joining us is Lauren Toreson, partner with Miller Thomson LLP. Lauren is a corporate and commercial lawyer working in Edmonton and Calgary, primarily in mergers and acquisitions, construction law, securities law, and secured lending transactions. Lauren also regularly acts for buyers and sellers on business acquisition transactions. Lauren provides practical advice and counsel in a number of areas, including procurement and contracts, drafting and negotiations, various forms of construction bids, and contract documents for all Canadian provinces for both owner and contractors. We are so pleased to have both Emma and Lauren with us here today. So thank you for being here. And now I hand it over to you.
Hey, hi guys. Thank you so much for joining Emma and I today. Just to give a little bit, maybe we'll get through the legal stuff first, but to give an overview, we're going to provide general information that I hope can be extremely helpful as you guys kind of navigate this new world. But always know that when you're entering into contracts, each situation is very specific, right? So where you may have, hopefully this advice is going to apply to a lot of your different events. There may be certain events that you should get specific legal advice, and so that we can ensure that different nuances are addressed. Today, when we talk, we're going to talk about some main headings. So form of contract, the scope of services and exclusions when you are setting out in your contract, the outline of your fees, deposits, refunds, delay provisions, limitation of liability, exclusion of consequential damages, and then different termination provisions and dispute resolution. I'm going to go through with Emma all of these headings in more detail, but just want to provide an overview of what we're going to discuss today. And then at the end, we can take questions and hopefully we can help answer any different questions you have.
I'll just jump in there to say, so it'll be obvious from hearing both of our profiles that Lauren is a contract drafter. That's what she does. And I'm a litigator. So the information I hope to provide you today is why these things that may seem not that important when you're entering into the contract actually are important when things go wrong. That if you end up having to sue on these contracts, having these provisions really help you.
Yeah, absolutely. That's a good point. So this is probably, we're going to lead off that point, the form of contract. So oftentimes, I'll have parties come to me and they're of course in a dispute, and, they will say to me that the parties had certain understandings, and then I will look at the contract that they have, and none of those understandings are reflected in the contract. So we have, in this world, a lot of parties use templates and standard forms, which I recommend, but they are just that, standard forms and templates. And they don't always reflect often the business deal between the parties. So you can start with a standard form, okay? But you have to then tailor it to suit the specific details of the event you are involved in. So if your contract says something with respect to payment terms or delay provisions or how the contract can be terminated. But then when you talk with the client, really what you're doing is different than what is reflected in the contract. You need to amend the contract up front. It is extremely, extremely important, because if you sign a legal agreement and that is what is going to be binding, regardless of what you guys have agreed verbally or orally between each other. Emma, do you have anything to add on that point?
Nope.
Okay. And so ensure that the procedures that are read in the contract are actually what you guys are doing. So if it says that the party is going to pay within 30 days, make sure that is actually what is happening. It's extremely important, because the contract is what is going to govern what is enforced. Definition of scope and services. I would say 60%, maybe a tiny bit less, of the disputes that arise with what your scope of services are. So I've looked at some of, Samantha was so kind as to provide me some standard forms of agreements that I know are used in your industry. And what was missing from a lot of them was a real complete detailed set of services that you are going to provide. Extremely detailed. And on the opposite, alternatively on that, what will you not provide? What is not included in your scope of services? I would say a proper scope of work should probably be about a page, a couple long, right? Depending on the size of what your project is. It needs to be so extremely detailed. You know, what are you going to be providing? When are you going to be providing? How are you going to be reporting to clients? What will your reports include? How will meetings be set? Every single thing should be set out, because when it is set out, it is then going to be harder for the client to come back and say it wasn't appropriately explained to them at the beginning. What is excluded? And then how detailed and how are these exclusions dealt with? If a certain service is excluded, can the client have you perform the service if they in fact will pay extra money for it? So make sure when you're looking at your contract, make sure you're clearly defined. It talks about when you're going to meet. It talks about your reporting requirements. It talks about frequency of communications and, what will happen at these meetings.
So I'd add here that when I look at contracts in the first instance, which is normally when things have gone wrong, arguably some of the biggest issues I see are very simple issues. For instance, if I'm contacted by someone who's solely concerned about the fact that they haven't been paid, there may be errors in the contract or not be a contract at all that deals with things that are very important to the practical effects of actually getting paid by someone. If you are providing a service for someone and you expect them to pay for that service, it's very important to identify who the person is that you are expecting to pay. Is that a corporation? Is it an individual? Who is it? And then you get that person to sign a contract. Because I'd say a good portion of the time when people are contacting me and the reason for the lawsuit is that they haven't been paid. The reason they haven't been paid is that they didn't have a clear contract who identified who was hiring them. When they sent the invoice out, it got lost somewhere in the mail. And then possibly like whoever it is who gets the invoice responds back to them and says, oh, I wasn't actually supposed to pay you. It was my client. And then you're left in the question of, well, we've already provided the services, but who are we supposed to look to pay for payment? And practically that is a problem, because the possibility is that if the contract was signed in the first place and the invoice got to the right person in the first place, you would have been paid without ever having to talk to a lawyer. But secondly, if I'm then going to sue someone saying that you were obliged to pay me and didn't, and I don't have a clear document saying that you are in fact the person who promised to pay me, you're going to have a hard time getting paid.
Yeah. And to add on that, it'll be payment, or it's going to be generally defined services is a lot of disputes I get as well, where it's, so in your industry, it'll be, event planning or management or administrative services. Well, what does that mean? If you can get in an argument when you read the contract as to what something means, I can tell you that is where the dispute will arise. It has to be extremely specific. So also it can't be that you can infer that service will be implied. So, I imagine, with wedding events, if you are planning these events and you are going to, manage the event, if you are going to administer the event, you have to be more specific on what that actually means, because between you and the client, it may be that there's a difference of opinion on what's involved in that scope of services.
And the other thing I would just add on parties, which I know we're going kind of back and forth, is that when you sign the contract, you need to make sure that your corporate name is on the contract, because that's going to protect you from liability, you personally, like you and your house, from liability, if at some point you do end up getting sued from anything that arose at an event.
So fees and deposits. So Emma's kind of led us into this, and I think it's extremely important. Money and how you are paid is one of the main terms of a contract. It's probably one of the most important terms of a contract. So every contract, of course, needs to talk about, clearly outline how fees are going to be paid. Okay. What are you reimbursed for? What are you not reimbursed for? What disbursements will you pay directly on behalf of the client, or is a client expected to pay on behalf of themselves? I would always get a deposit or a retainer from the client upfront, especially when you have these upfront costs. The best way to protect yourself from loss of money is to get the deposit and retainer upfront. You're going to have a pretty clear indication on how hard it is to get that deposit retainer in the first couple months of services, if you're going to have a problem with this client. So if you hold, say, $5,000, the client gets it to you, and you then have money in hand, and you show them that you are providing the services, and you give them a monthly accounting for what their money was used for and why. It's better than performing the services and then asking for money after, especially in this COVID world, right? Because people's economic circumstances are changing daily. So, you may do a month or two of work, someone loses their job, and then you'll be out of luck. You can try suing someone for $5,000 or $10,000, but to be honest, the legal cost in recouping that amount is not going to be worth it. So dealing with pandemic, anytime, it's utmost important to get a deposit or retainer upfront. And I would keep getting deposits and retainers as those deposits and retainers are used in the performance of your services. I would also have, in order to prevent any loss, I would have the client, you will negotiate the contract on behalf of the client with a third-party vendor, but I would have the client being the party to that contract. So they will actually enter into that contract and pay the third-party vendor directly. Emma, do you have anything to add on that?
Yeah, the one thing I'd add in terms of payment is that if you can get it, it's great to get a clause in your contract that provides that if you're not paid, you're entitled to interest at a specific rate, as well as the legal fees you incur in collecting on any unpaid accounts. Like, a lot of the time, these sort of clauses are going to be non-starters and people want them removed from contracts. But if you can get them, it's great. And I say this because the first question most clients ask me when they're talking about a lawsuit is that they say they want the other side to pay for their legal fees. And I always tell them, we'll try, but unless you have a contract provision that allows it, it's unlikely that you would ever actually get it. And that's because we have court rules that provide if you win at the end of a lawsuit, you get certain specified amounts for fees and certain court-ordered interest, which is in accordance with legislation, and it's close to prime. So it's very minimal. But if you have something in your contract that allows you to get more, there's a greater possibility that if you do go through the rigmarole of a lawsuit, you end up getting more of your money back out of that. Similarly, I think if you are entering into agreements or negotiating agreements on behalf of your clients, and there are those sort of interest provisions in the agreements they're going to be signing, you would probably want to negotiate to remove those.
Yeah. So just to summarize, clear outline of fees payable, clear outline of how you are reimbursed, what is a reimbursable expense, what is not a reimbursable expense. I would get regular deposits and retainers from the client as you go through, so you'll have money in hand. I think that's always the safest bet. And I would have the client enter directly into the contract with a third-party vendor, so you are in fact not on the hook for them. And then also with what Emma Point said is if you want to get interest and legal fees, which for late payment, which we always recommend, ensure you have a provision in your contract that allows you to recoup those amounts.
The one thing I would add on that is a lot of people put their interest provision at the bottom of their invoices, and that's not really good enough. It needs to be in the contract.
Yes. Trying to add legal terms, right? On the bottom of an invoice or in your back schedules, they're not always going to be effective because in law, we have what's called these priorities of documents, right? Usually your main contract terms are going to be given the highest priority. So all of your legal terms need to be in your contract. Don't try to add them later in your invoices because they may or may not be enforceable. Delay. This is an extremely important clause in the climate we have right now. It's different than event of force majeure, which we will get to. So delay is, you're not necessarily completely prevented from performing, but you are delayed in performing, right? And so so you need to deal with both, okay? And so when we talk about event of force majeures, you are prevented from performing. A delay is, it just may be that you can't perform to the schedule you said you were going to perform to. I would always have a delay provision in. What does the delay say? It just says basically in the event you cannot adhere to the schedule you said you were going to, what happens? Does the client get some money back? Do you then get to keep your deposit if they are delayed? So always make sure you're going to have a term like that saying what happens. These aren't complicated terms. It's just turning your mind to what's going to happen in the event a certain event occurs. Okay. Who receives what money? Who gets something back? I put a COVID acknowledgement in because we have started to add these into contracts. And the reason I didn't give you a specific term is that they're extremely specific to the event you have. So what does a COVID acknowledgement say? Basically says that COVID now has been here for arguably a year, right? Depending on where you are in the world. And so people are pretty aware of what can happen, right? That doesn't mean that there can't be extraordinary circumstances. It just means we're going to have people say to our clients, I, client A, acknowledge I'm aware of COVID-19. I am aware that it can cause delays in the performance of services. In the event it does cause delays in the performance of services, this is what's going to happen, right? So you expressly have that acknowledgement given. What does it do? It stops the party from saying, I wasn't aware that this, I wasn't aware that this would happen. I wasn't aware this could happen. I think what's the benefit of having these last 8 months is we've seen how different events can play out. We've seen how different government orders now can affect your industry. And so it's time to start kind of taking those and putting them into your contract and having that acknowledgement. A government order may come down that prevents you from a venue from being provided. Okay, what happens in that circumstance? Do you keep your deposits? Is the event just wholly delayed? So let's start having all of that put into the contract and turn your mind to it. And I would discuss it with the client at the time of signing. I think sometimes parties think it's better to kind of wait till it happens and, think if they're negotiating or they're trying to attract a client, that it's better to just kind of over promise. And I would actually take the exact opposite stance. I would say, sit down with your client, talk about what you've seen in the last 8 months, talk about what you've had to deal with in the last 8 months, talk about how you have dealt with delays that have occurred, and then put that into your contract on how now you are going to deal with a delay in the event that, government order comes down, which basically prevents you from performing in the way you said you wanted to. Anything, Emma, on that?
No, I'll talk about delay and force majeure, I think, together. And terminate.
So let's go to force majeure. So this was, I think I dealt with this every single day from March forward for, 4 or 5 months. And it really, previously when we had been dealing with force majeure, it really was just like a standard term that you put in your contract. And People just kind of, glossed over it, right? Now, as a result of COVID, we have had to really take a look at what is a force majeure. So one thing you should know, force majeure is completely contractual, okay? So what your obligations and your rights are in the event there is this kind of event that's like this act of God that completely prevents your performance, it's all going to depend on what is in the contract. Now, we do have these different concepts called frustration and things that are the common law that you can try to rely on in the event you don't have something in your contract, but they are a lot more archaic, I would say. They're not often argued. And so what has come out in the law is really, I think, has been decided on probably 30 years ago, 40 years ago, and doesn't necessarily contemplate a COVID world. So our recommendation to all clients we deal with, look at your force majeure clause and let's set out how an event of force majeure going to be dealt with, what is a force majeure, and what are parties entitled to in the event a force majeure arises. One thing to note is that the event of force majeure must have actual and direct impacts on your ability to perform. So one thing I saw a lot in March and April is we would get these notices from suppliers, from contractors saying, oh, I'm claiming an event of force majeure because of COVID. You can't just say COVID is an event of force majeure. You have to say COVID has prevented me from performing on my contract in this way. And you have to be descriptive in how it's prevented. You can't say, I anticipate it's going to delay me. It's got to prevent your performance. So let's look at a sample clause because I think it's going to become clearer to you guys. So when is a party's performance excused and what is an event of force majeure? So if you look in some of your contracts I looked through, this is a sample clause as to what was in there. This, I would say before COVID was probably, we saw it a lot. But I would say now in light of COVID that we're kind of really dealing with these events, a natural disaster in ways, right? An act of God. This is what we are recommending now. So if you look at it, we have a general description of what an event of force majeure is. Why do I put this general in? Because when you put specific events, right, of like earthquake, flood, pandemic, epidemic, the situation that has arose may or may not fall into those very specifically defined categories. So we really want to look at what is the nature of a force majeure, and then we want to get that into the contract. So we are now saying it's the occurrence of an event or circumstance that prevents or impedes a party from performing one or more of its contractual obligations under the contract. And if and to the extent that party affected proves, so the party who's trying to claim has to show it's beyond their control. What does that mean? It means you couldn't have taken steps to prevent it from affecting you. B, that it could not reasonably have foreseen at the time the conclusion of the contract. So again, what does that mean? That goes back to our COVID acknowledgement. Like I said, COVID is here now, okay? So you guys are going to have to plan your events in light of COVID. So you trying to say, oh, I wasn't aware that maybe a government order, maybe could affect me in this way. You're going to have to take a look at your business and start planning in light of COVID. Trying to take steps at the forefront on what you guys can do to mitigate its effect on your business and on the events you're planning. And then see that the effects of the impediment could not have been reasonably avoided or overcome. So if you see in all three of these, it's basically the thought of, could you have taken steps beforehand to mitigate the effects of the event on you, right? So could you guys, when you met with your clients, have anticipated some of the effects of COVID? And could you have done things to prevent it from affecting the event? And then we go further and we say, we assume list of events. These specific listed events will be deemed to be an event of force majeure. So war, civil riot, currency trade restriction, active authority, so compliance with any law or government, plague, pandemic, epidemic, and so forth. you will see that we've specifically put in compliance with any law or government order. When we were dealing with a lot of these contracts in, when COVID first hit, most contracts really just dealt with major events, floods, war, riot, explosion, etc. What it didn't deal with was government law or orders that prevent you from performing, right? So you may have COVID, but was it COVID that prevented you, or was it really the government order restricting gatherings? Right? So you need to make sure we have this wording of any law or government order, because again, you have to be able to draw it back to what the actual impediment was. Emma, do you have anything to add on that one?
I think what I would add generally is, as you've said, we have very old case law on these sort of situations, and we can't really predict what will be litigated or what decisions may come out in the next few years arising from COVID. It will probably come out of that March, April period where people couldn't plan in advance for it. But obviously you don't want to be the test case, which is why putting these provisions in your agreements and termination for convenience, which Lauren will get to, are giving everybody hopefully an out where maybe you can both get away from it with some savings and get out of your obligations without having to have a lawsuit to determine who's actually obliged to do what. Of course, I think we can expect the test cases to be where we're talking about major money. So large construction projects, those sort of things are likely to be where people start to push the boundaries of what force majeure and actually meant in this instance.
Yeah, and I think that's an extremely good point. We want to give you guys a way to get out in front of this and to deal with these right at the time you're negotiating these contracts. You don't want to go to litigation. I can tell you, any lawyer is going to tell you that a claim of 10,000, 20,000, maybe 30 up to 50,000 is maybe not going to be worth it to pursue in court. Why? Because it is going to be extremely expensive for you to pursue that action to the end. Secondly, we are backed up, right? Courts are backed up. So you could be years out before you'd ever realize this money. So we're trying to give people ways to deal with this up front. Secondly, I'd also tell you to be reasonable. We, when I'm talking to my clients, they have billion-dollar projects, and they've taken major hits on these projects, but you need to be reasonable. I mean, COVID hit everybody. It's caused delays all over. That doesn't mean you allow a delay that's maybe not a proper delay or a proper event of force majeure. It just means try to work together to come to a reasonable solution.
What I would add on the litigation side from that is that I think that's what courts are going to expect from you. They're going to look at this and say, everybody was dealing with a very difficult situation. We needed to work together to get out of it, as opposed to trying to strictly rely on what your contract may say. Yep. So the courts are going to expect that when they're looking at these lawsuits.
Yes. And I think that that has been signaled by our government, right? Because they're trying to help people. They're putting programs in place that are trying to provide subsidies. I don't think the court's going to want to see a bunch of claims. There are obviously going to be test cases. There has to be. It's a good chance for the court to look at the law and to kind of bring it up to date. But the element of reasonableness or the element of mitigating your losses where you can. So termination provisions, this is kind of the other extremely significant point you should have in your contract. You can have a termination for fault, and termination for fault is where there's material breach of a term of the contract, okay? Oftentimes, most contracts have this. They will have a provision that says, okay, if you materially default on our contract, we can terminate. We can, terminate within 15 days, stop performance of services, and withhold your money. I would say a lot of contracts have that. What they don't have is a termination for convenience. And this is probably the main provision you should have in your contract. What is that? It basically is a clause that says you or the client can terminate the contract for any reason whatsoever upon a certain notice period, which usually can be, 15, 30 days, maybe even 60 days. You have to pay for all services performed to that date. You usually have to pay for unavoidable costs that were incurred as a result of your termination. Why do I recommend having this in? Because fault is extremely hard to prove. You can think something like stealing is fault. You can think fraud is fault, and it probably will be, but it's extremely difficult to prove, especially when the facts are usually gray. They're not black and white. So again, you don't want to have legal costs coming, trying to prove that the other one was wrong. What you want to be able to do is cut your losses, terminate the contract, and walk away. That is what's going to save you the most money. So what I always say is put a provision in that either allows you to terminate or both of your parties, you and the client, to terminate. What's the length of notice you're going to have to give? And then what payments are needed. In the result, you do terminate for convenience. So you usually say your notice can be 15, 30 days, and you'll say you'll pay for services, or the client's going to pay you for services performed up to the date of termination. And then you could probably just leave it at that. Emma, do you want to add anything on that?
I'll add something on the termination by fault, because you have the line in there about insolvencies. I think this is something you should be thinking about when you or your clients are entering into agreements with venues, in that I think everybody is a little worried about the number of insolvencies we're going to see in those sorts of businesses, that if you're giving deposits to these people, that you're unlikely to get it back if they go under and are unable to perform the contract. That's going to get funneled off to their bank some way. So you may not be able to get around providing deposits, but there is that risk there that if you give it, it's not coming back to you.
Absolutely. And that's why I think it goes back to our one of our points on the previous slide of don't, if you are operating this event planning business, don't you give the deposit. Don't front the money for your client. Deposits should be paid directly by the client, or, you can pay the deposit out of the retainer you've got from them. That's fine, but it should not be your money, because it's probably not coming back. Limitation of liability. So these all kind of work together. So what's a limitation of liability? So in common law, means the law that's been decided through court decisions, right? So it doesn't really matter what's in your contract. You can be liable for negligence, you're liable for breach of contract, and then, you're also liable for what is said in your contract, okay? And what we want to say to you guys is, you need to have an overall cap on what your liability is. Why? And probably for the clients as well. Why? Because you cannot, as business owners, be liable for unlimited amounts of money. Okay. It will sink your business, regardless of the insurance you have. And you don't always recover insurance monies, as we all know. So you need to know what your risk profile is. And this is what I say to owners of businesses. You need to say in the contract, regardless of what I do, regardless of, my negligence, I am only going to be liable to you for a certain amount of money. And I make it pretty clear cut. I always recommend to my business owners, you can get kind of extremely trickily drafted or complex drafted legal provisions on this, but I would make it straightforward. I would say my aggregate or my company's aggregate liability under this contract, or for my negligence or warranty, anything, is going to be limited to, say, the amount. It can be the amount of money equal to the amount of money that they paid you. It can be a dollar value. You can assess what the contract is worth. Say it's worth 100,000. Maybe your liability is limited to 100,000. Maybe it's only limited to the amount of insurance monies you received. You can make, there's no kind of wrong or right. I would say what the decision is, it has to be amount of money that you can afford to pay. That's not going to result your company in having to file bankruptcy, right? Because you need to be able to operate, right? Lawsuits happen, disputes happen. You need to be able to kind of weather that dispute and still be going on performing your business. So here's a clause. So this was a clause we had from another contract. And so it's the client agrees not going to make a claim against events. and that they're going to cover and hold harmless the owner company from liability arising from loss, injury, loss, damage to person's property occurring directly, indirectly, and then it has up to amount. So this is good for the client then indemnifying you, but I would also go further and have what is your liability to the client going to be, right? As COVID hits and as, you know, maybe perhaps you are prevented from performing a certain, your services, you could be facing lawsuits from clients. So you need to have this overarching limit on what your liability to them is going to be. And this would be the proposed wording that we would go for. You can see we say the owner's liability under the contract, whether in contract, tort, warranty, or otherwise. Why is that important? That is important because it's whether it's under your contractual liabilities with them. Tort is negligence. So maybe it's not arising from your contract. It's arising from how you have performed, right? So that's tort. And then any kind of warranty you've given for your services. And then we will put the limit in, which can be the monies that you've received or the insurance monies for the policies you have. Emma, do you want to add in on that?
Yeah. So these sorts of clauses are very important. First, because one of the first ways people might try and avoid paying you for your services is by saying that they have some additional costs as a result of your breach of the agreement. So you want to be able to limit their ability to claim those against you. Secondly, something goes very wrong. For instance, there's some event at your event that leads to tortious liability. You want to be able to limit that claim against your corporation. You certainly don't want it to be a claim against you personally. You want it to be a claim against the corporate entity, but you don't want that to be so much money that it, for instance, exceeds your insurance liability. The bottom line there, of course, is if you haven't talked to your insurer about ensuring you have insurance to cover these situations, you certainly should have. So it's hard to sort of guess at what sort of lawsuits we might see coming out of COVID type situations at events, but there probably will be some. And so you need to talk to your insurance and make sure that's something that's going to be covered, because when you have insurance that covers something, they defend you. That means you're not paying for the legal fees associated with the defense, and they pay for any judgment against you. And this is one of the questions we got in advance of today about whether or not there could be scenarios where there was civil liability for, say, someone getting COVID at an event and dying. We obviously haven't seen those cases yet. The question is whether an event planner would have any liability as well. I think we will see those cases because we already see cases that are quite similar to that in the personal injury realm. So we see cases where you're suing someone because you're injured in a car. We see cases where you're suing someone because you got punched at a bar and you want to sue the bar and allege
letting them drive drunk, letting someone leave drunk.
Yeah. So it would not shock me to see personal injury lawyers bringing these sorts of cases. And the reality is when we see those lawsuits, what we see is they sue everybody who had anything to do with the event. They're going to sue the venue. They're going to sue you. They might sue the client who is holding the event. And you need someone to defend that, because you can't spend all of your time, your personal time, defending that. That's why you want your insurance company to do it for you. But the reality is that you could theoretically see situations in which a court might ultimately find that you, as the event planner, did owe a standard of care to these people attending the event, particularly if in your scope of services, you've set out a service you will be providing is attending to this sort of health and safety requirements of the event, that you've then made the promise in your contract that you're going to be doing those things. So the court recognizes standards of care in all sorts of situations, doctors to people, to their clients, drivers to other drivers on the road, and you could see them recognizing a duty and standard of care in these circumstances. So what you need is insurance that's going to deal with that for you.
Yep. And I mean, if I argue on any single contract, the one provision I argue for the most, and I will usually recommend not signing a contract unless it has it, is this limitation of liability. If we lose every other point when I'm negotiating, I will not lose this one. Okay. So like Emma says, make sure you have insurance to cover it, but also limit your liability to, one of these amounts, right? Contract value, insurance monies received.
I would also say that if in your scope of services, you're saying that you're not going to be responsible for health and safety of the event, I say, you're probably still going to get sued anyway if it's not in your scope of services. But that's something that's extremely important to discuss with your client and have them acknowledge that you've told that. So they should even maybe be initialing beside that portion of the contract, because the reality is they're probably expecting you to do those sorts of things. And what's in the contract is going to influence what this standard of care you owe to these people is. The other thing I would indicate is just in terms of assuming you've taken on the responsibility of doing these things, you want to document the fact that you have in fact done them, because lawsuits are about evidence and about whether you have done the things you were supposed to do in accordance with the contract and whatever the standard of care is determined to be done. So if you have emails showing that you asked the venue about following these things, that you had satisfactory responses, that's going to be evidence that you did what you were supposed to do. Similarly, if you have notes or whatnot, that's going to be evidence of what you did.
Yep. If there is, we document as lawyers, we document everything, every meeting, every email. You'll see doctors. I have a lot of doctor clients. They document everything when they go into lawsuits, even from 7 years out. So document everything, keep every email, make sure you have proper contracts. If you have an incident happen, document it all, right? Note what you've done from a health and safety perspective, just so if something ever arises, you can go back and then rely on those records going forward.
So the only thing I'd add to that, we also got a question about whether or not there could be regulatory or criminal fines or charges, just so it's clear to everyone. And not every lawyer in our office has familiarized ourselves with everything to do with COVID. We have one person who knows all about it. So I asked her, and she did think that most employee claims should be dealt with by workers' compensation, assuming workers' compensation applies to the business. It's possible that there might be occupational health and safety fines, but that would particularly be most likely in a scenario where employees were potentially affected as opposed to guests. And there's also potential room for criminal charges, but again, it's not likely. And so these are sort of situations similar to like construction negligence. It has to reach a pretty high threshold before someone's going to decide that they want to bring criminal charges. It's not just the baseline of, maybe everybody wasn't as perfect as they should have been. It has to be very bad behavior. And if anyone wants to talk to her more about those sorts of things, we can put you in touch.
Yeah. It's hard to have answers on, no one has affirmative answers on any of this. What we're trying to do is put people in a position that they can protect themselves, in the way they need to in light of, COVID happening. But to be honest, probably it'll be a couple years before all of this is determined, right? And so we're trying to have people anticipate and, be diligent at the forefront, and then, hopefully to avoid these claims that are going to be made. Consequential damages. So consequential damages is a vague kind of legal term. If you ask any lawyer what they means a lot of lawyers kind of struggle and grasp what they mean. But consequential damages are these type of indirect, unforeseen damages that happen. Okay. So, you can see that as, an event planner, that if you, allow someone to say leave a party and they're drunk, let's say intoxicated, and they drive off, you can easily foresee that they may harm someone else, they may harm themselves. What you maybe can't foresee is that they were going to drive through a building and severely injure an owner, and that owner now is going to lose a mass contract worth millions of dollars, right? So you see, as we get farther and farther away, you have these kind of indirect losses that are really hard to anticipate, but they can be worth millions. Okay, so when you are liable under a contract, again, it goes back to this risk profile. You need to say, at some point, we have to cut off our losses. At some point, this business owner cannot be liable for these type of losses that they never could have anticipated occurring. You have to write it into your contract, though, specifically write it in. And so this is a sample clause I recommend you guys can put into your contracts. Obviously, when you see terms like owner and client, it's going to have to be properly be, you'll have to amend that to be your company's name or the client's name, or however the parties are defined under the contract. But we're basically saying, notwithstanding anything else in this contract, neither of us are going to be liable for these following types of consequential indirect losses. And you have to specifically list all of these, right? In order so you can exclude yourself and prevent you from being liable for these type of losses. This should be a standard provision in all your contracts. I will say too, a lot of insurance coverage will not cover these types of losses for you, right? Because they will have exclusions for these types of losses because they can be so mass and so significant in amount.
I think that goes back to, like, for instance, I have a client right now whose insurer has denied them coverage. The claim against them is $8 million. Even if they had insurance coverage, they'd only have $5 million worth of coverage. So assuming that that entire claim, which does include these consequential damages, was made out against them, their business is not going to survive. In some ways, it makes more sense for them to just go bankrupt now than to have this lawsuit play out over the years and defend it. So why you need insurance, but these clauses help a lot as well.
Exactly. They help. Even if you have insurance, insurers still want to see that you've limited your liability under these contracts. You have to turn your mind to it and, get a proper termination, get a proper limitation of liability clause, and, a proper exclusion of consequential damages clause. That can go a long way to limiting your liability under these contracts. And lawsuits happen.
They do.
Dispute resolution. So I will say that the popularity of dispute resolution clauses, I think, change with how fast the courts are operating. In light of the business you guys are in, I absolutely recommend putting in a dispute resolution clause. So what is it? It's basically, we set out the mechanism for how you guys are going to problem solve during the contract or for disputes that arise. Courts right now are significantly backed up. Okay. And we're talking, I don't know, Emma, how long does it take to get into court right now?
Oh, I'm sure it'd be like 5 years to get a trial date if you were acting very aggressively.
And so in that time of 5 years, you are incurring legal costs all the way through, and significant legal costs. People don't underestimate the cost it takes, the amount it takes to get to trial and through trial. I would say an average amount of trial, it can be upwards of $100,000 even of trial. And then you have all the 5 years before. Large amounts. So we now say for when you're dealing with, these contracts, put in a dispute resolution clause. Put in, are you guys going, if there's an argument, perhaps you have, the senior, you'll have, your owner or your project manager meet to discuss it, try and come a resolution there. If that doesn't work, maybe we go to, mediation, and then we will pick a third party mediator who's going to help us. And then if that doesn't work, maybe we'll go to binding arbitration, and then we'll have, a third party unbiased arbitrator that can then decide this. So it puts in forth the mechanism for how disputes are going to arise. It also will say that parties will continue to perform the contract even in the event of a dispute, right? So we don't just keep having a total stoppage of work. And then it just helps you can avoid the court and litigation system.
So my addition to that is that the court's not always such a bad thing. It really depends on what dollar values you're talking about. Because if your claim's under $50,000, though it may have gone up lately, you can bring your claim in small claims court in Alberta. And you don't have to have a lawyer for that, but it's useful to have a lawyer. But if you file your claim there, they defend. The first step is a pretrial conference, and that's with a judge. And that's like mediation, but those claims frequently get settled at this step. And it's cheaper actually for you to do that, more likely than go through a private mediator, because you'd have to pay the fees of the private mediator as well as others. As well, once you have a court order saying that you have to show up at this pretrial conference, they're a lot more likely to show up because there's an actual judge telling them what to do. So it's somewhat dependent on how much money you are talking about and how much money you want to put into it. Because if you get past the $50,000 level, you have to go to our higher level court, which is called the Court of Queen's Bench, and everything there is much more expensive.
Yeah, and they oftentimes, Emma brought up a good point, they'll force you to a pretrial conference, which is like mediation.
Mm-hmm.
Courts want you to settle and work out your disputes. I think that's, Emma, do you think that's fair to say? I mean, they don't want people,
Yes,
if they don't have to book in a week. Yeah, yeah. And I would say 80% of these disputes are, can be resolved, right? Through kind of, you have a little bit of reasonableness and maybe an unbiased third party mediator who's familiar with.
Claims under $50,000 settle at a pretrial conference at small claims, but the same client with a similar sort of person not paying them at $75,000 in the Court of Queen's Bench drag on for years, because you never get forced to this mediation step where you're likely to settle a claim.
Yeah. Yeah. So turn your mind to how you guys can resolve disputes. Okay, so what makes a good contract? You don't have a good legal contract. It doesn't have to have all this wording that no one knows what it means. Okay, clear, concise, plain language, straightforward. Okay. Second point, legal terms actually reflect what you are doing. Goes right back to these standard forms or these contracts you're using. If they don't reflect your business practice, change them. Okay, it has to reflect how you operate your business. Otherwise, you're going to be continually acting in contravention of your contract, right? Avoid duplication of terms. So put your legal terms in your contract and only in your contract. In schedules, you put your scope of work, you put what fees and how you're going to be reimbursed. Don't slip legal terms on your invoices. Don't slip legal terms on supplemental notices you send out. All legal terms need to be in the general conditions of your contract. Otherwise, they may not be enforceable. Avoid conflict between terms. I see this 80% of contracts I see. So people have this important point and they keep putting it throughout. They keep putting it throughout the contract, all their schedules, all their invoices, but they say it in a slightly different way. And so now it's become confusing and it's ambiguous, right? If you want a limitation of liability, put it in your main terms in one place. That's it. You don't need to re-say it, okay? If you are not going to be liable for a certain type of loss, put it in one place. If you want one place, right? Don't keep duplicating it throughout your contract, because I can tell you most times there is an issue and there's a conflict between terms. Don't skim on scope. So clearly outline all the services you're going to provide and what you aren't going to provide. If it's 3 pages long, but it's extremely detailed, I would think that adds more than having a couple of lines of general terms. You're more likely to get an argument when it's like that. And it's not always necessary to reinvent the wheel, right? So standard terms have their place, right? And they are extremely helpful. I would say probably in 60% of the time when you have a certain dollar value, right? So you can use them. Just make sure that they say what you're actually doing. Emma, do you have anything to add on those?
No.
Okay. And now I think questions. Do we have any questions?
So thank you for that presentation. If anyone does have any questions, please feel free to drop them into the box below. But We do have some questions that were submitted in advance. The first one I have here was, has Miller Thomson had to investigate the laws around pandemics? This hasn't happened since 1918, other than the SARS outbreak, which is nowhere near as bad as COVID. How do you prepare for a group like ours with all of these legal questions that may not have any current precedents?
So we go back to basic premises. So first question on that, we have been having to investigate this, I think, every single day since the shutdown. We have had mass meetings, all different practice groups, and we always overlap and, nationally, right? Because we are a national firm. So every single office has been investigating this, and we've all been working together. And I would think that part of your answer is how do we prepare? I think we go back to basic principles. There are thousands and thousands of cases that have been argued in courts that maybe haven't been dealing with COVID, that don't deal with COVID, but they deal with natural disasters, they deal with acts of gods. And so what we do is we look at the premises that come out of those and what the court has said, and we try to basically anticipate how they are going to apply in this scenario. And then I think we counsel clients on what are steps that we can take, regardless of how COVID is determined, that are going to help you have control of your business, right? And so it's just what we talked about. When I say to you in your contract, have an event of force majeure provision. Why? Because maybe we can't anticipate how a court will react to COVID, but we can anticipate that a court's going to enforce contractual obligations, right? We can anticipate that if you have a limitation of liability clause in your contract, the court, and it's clearly written, the court will more than likely enforce those provisions in the contract. So we're trying to give you guys tools to limit your liability no matter what the court decides. Emma, do you have questions on that? Anything to answer on that?
Lauren's practice has involved much more talking about this than mine has. Mine has really been a matter of, how are we moving litigation forward, notwithstanding the fact that everything has changed and the courts are very delayed and there's all sorts of problems there. But you can only look back at what's happened, and then if you have to look forward to litigation, I think we're not seeing that yet. That's something we're going to see in the next year or two.
We're trying to draft contracts that will work regardless of how COVID, plays out in the courts, right? Sometimes that's why we're saying get a right to terminate the contract. Expressly say how you're going to deal with delays, because one thing we're fairly certain of is courts enforce contracts and they enforce written agreements in a lot of scenarios. So we try to give people tools to mitigate their losses.
Someone asked, presuming production or venue staff are in a role of reminding guests about how they need to be compliant at an event, are there any legal risks associated with this?
I think I covered that off in my discussion of, what the standard of care is and the likelihood that a court would expect anyone involved with an event to have some sort of duty of care and standard of care towards people attending it. They'd also expect the people attending it to know what the rules are likely and comply with those. So there is the legal risk that some people will get sued as a result of COVID outbreaks or whatever happening at events. We can't predict what exactly those are going to look like, but I would be shocked if we didn't see those sorts of lawsuits, because somebody will try it, right?
Yeah. And I think that then being familiar of the current orders in place, right? And what the current rules are, and trying to ensure or do anything you can to ensure they're complied with, right? So 15-person limit, if someone's knowingly breaching it, I think you'll have, an obligation as being in planner to, maybe take steps to make sure people are notified, et cetera. So be familiar with the current orders in place and, do your best to ensure they're complied with.
And you guys have mentioned a lot of things to note in our clauses, in our contracts, but can producers protect themselves by putting in a health agreement in place with vendors to ensure, at least legally, that the vendors are taking health safety seriously?
Yes and no. I think like with any contract, it doesn't hurt. Again, I'd go back though, you can always have, so you don't want multiple contracts, but what you can say to your vendors is, I mean, you're going to sign a contract with that vendor. Again, it goes back to these principles, right? They acknowledge COVID. You'll want them to acknowledge that they are taking all safety precautions. They're responsible for their health and safety at the venue. They are in charge of the venue, right? And so just like Emma said, where you almost have, it goes to your client's contract with the vendor. You have them specifically acknowledge that they've taken health and safety precautions in compliance with applicable legislation for COVID, right? Or for all of this stuff. It's just covering your bases.
And I think you want the opposite to be true, that your clients are, you've said the COVID acknowledgement in that context in terms of like if there's delays, but acknowledging that if they're having an in-person event, that they need to be aware of and comply with health provision. And all of this to say is not going to stop you from being sued, but you want to make sure that everybody else is responsible as they can be, and that your liability in the event you are sued is limited.
Yeah, nothing prevents you from being sued. I think people should recognize that. When lawyers sue people, they name everybody. They name everybody as of right. Anybody who can be involved, they will name you. This will help you to get off that lawsuit and to limit any liability. Just because there's rules around how you litigate, right? That, Emma's way more familiar with, but as a basic practice, we name a broad number of parties.
Yeah, and most of the time when someone's been injured as a result of negligence, it's not altogether clear to the lawyer or the person it happened to whose fault it actually was. Yeah. It may be the fault of many parties, so that's why there's contributory negligence. So if a guest gets COVID and something happens to them, they have bad health outcomes as a result of that, and they sue the event planner and the bar, there's going to be the argument back to them, well, you were aware of these provisions as well, and you were contributory negligent. And so you're part of the reason that you got COVID. But the lawyer just sues everybody. So, yep.
And we don't always, when you're suing someone, you don't have access to all the records up front, right? So you name everyone so you can get access and then determine how you want it to play out.
I got a question come in here saying, with frustration and force majeure, do you need to wait until the event day to know that it is in fact applicable?
No. No, I would say, so frustration is, it's an archaic doctrine, right? And I don't know if you agree with that, but it's not something we always want to rely on. The long and short of it is no, you do not. You may need to, though, wait till the event date to see if it's continuing, right? Like, remember with force majeure, it prevents you from performing at that time, right? So maybe, let's go back a minute. In March, we have a government order that prevents these events from happening. Perhaps these events, though, that government order were lessened, and they were, and the event was in July, but so in July and August, we got some of these orders were lifted, and then the event could happen. So it just delays performance. It prevents it just for that specific period of time while the event is while the, I would say the act of God is taking effect. But so you're going to have to see at all these different points where you have to confirm that you are always prevented from performing. Right? I don't know if that's more clear, but you maybe can't perform in March, but you can perform in July.
I would also add that in respect to frustration and these other sort of archaic things like rectification, there's all sorts of contractual remedies you can get. If you're at the point where you start having to argue these things and you don't have something in your contract that actually deals with the situation, you've somewhat already lost, because you're in for a long, messy lawsuit about whether or not it actually applies, who said what happened. You don't want to have to argue those points.
No, those are last ditch efforts in a lot of cases. Yeah, I'll be honest, right? Like, they're what you put in, frustration, but if you have it in your contract completely spelled out, it's way better for you.
All right. I guess the last question we have here, unless there's something, no, there's one more after this one, but virtual event contracts. Do we need to be doing anything different in these as opposed to live produced events?
So I would say exact same premises apply. I mean, listen, virtual contracts are, I mean, they're different in the fact you're dealing with a different media, right? You're not live is different than virtual. However, the premises still apply, right? So you're still going to have termination. You're still going to have limitation of liability. You're still going to have events of force majeure. You're still going to have a clear scope of work. And so no, our basic, our presentation applies to all of those. If you look at, say, a consulting agreement and then a industrial construction agreement, two completely opposite types of services, you will see these common provisions throughout both contracts.
And one last question here. If someone attends an event and claims to have contracted COVID and tries to sue, how can anyone prove that it was at the event as opposed to another location that they got sick? It seems to me that knowing when and where you contracted an illness is not an exact science.
Yes, so that's an issue in all negligence lawsuits. I mean, if you got injured in a car accident, the insurance company defending that claim, the first thing they're probably going to say is, well, did you have a bad back before you got injured in this car accident? So the reality is that the ability of the plaintiff to tie it to a specific event will be key if they can't satisfy the court on an evidentiary basis. And that's something called they have to satisfy them on the balance. That's 50% plus one, essentially, that it's more likely they got it there than somewhere else, then they wouldn't be successful. So I'm sure that's something you would defend based on. That said, if, like the wedding we have in Calgary where 49 people seem to have been traced to that event, you can see that they're going to probably get past that 50% plus 1%. Similarly, you can, in any trial, there's going to be expert evidence. So there would be evidence from doctors that would likely attest to how and when they got it and why they think they got it in a specific event.
To that point, though, I think it's important to, just adding to Emma's is that, you see, when my children now attend sporting events, when we're going to work in our office every single day, we have to do a COVID acknowledgement, right? Just to attend work, we do a COVID acknowledgement. And so it's something Alberta's put out there, what they think their standard COVID acknowledgement is. It's widely available, prior to hosting these events. It may be a good idea to have every guest execute one, right? At the door, come in and say, hey, we can attend and we meet these criteria. What does that help with? If someone does get COVID, from an event, you now have all these COVID acknowledgements where everybody over the age of 18 has now acknowledged, or their guardian has acknowledged that they were, in fact, could satisfy the COVID acknowledgement. It just helps.
Well, thank you, Emma and Lauren, for being here today. We had a lot of positive things. I saw people writing profusely on the monitor, as well as I received a whole bunch of questions of thank you. So again, as mentioned, we'll be sending out this recording to our membership, as well as both Lauren and Emma's contact details if you have any further questions or would like to get your contracts looked over by them. We just wanted to remind everyone that we do have some upcoming events. On Wednesday, November 4th, we have an exclusive membership-only tour of the brand new Stanley Milner Library. On Thursday, November 19th, we are planning a hybrid event all about rebranding and pivoting during and after COVID. And then on Thursday, December 3rd, our COVID recovery series continues with a deep dive into all things insurance. So again, thank you to have Miller Thomson sponsor this event today. And again, Emma and Lauren, we appreciate all of your guidance, and everybody else who's watching at home or at work, please do enjoy the rest of your day. And if you have any other questions, again, please do reach out. Have a great day, everyone.
Yeah, thanks.
Bye, everyone. Thank you.